Good everyone, welcome to Legal Corner powered by Vision Kings, where we'll be looking at a very interesting topic today, which is an adumbration on the relevance of natural theory of law juxtaposed with positive theory of law in Nigerian legal system. So, an adumbration on the relevance of natural theory of law juxtaposed with positive theory of law in Nigerian legal system. So we're going to first of all have an overview of the natural school of thought, the criticism, then an overview, the brief overview, positivist theory of law, the critics as well. Then we look at finally their relevance in Nigerian school. Before we continue, we'd like to introduce ourselves. My name is Osu C. Emmanuel. While seated with me here is
I'm Efrebo Destiny.
All right. Before we continue, Mr. Efrebo, can you take us through the importance of this topic today?
Okay. Good afternoon, everybody. The topic today is a very interesting topic. Upon coming across this topic, I was so happy that the Legal Corner sponsored by Vision King is actually taking on such a topic like this, because I feel like, to my own conscience, these two schools of thought are the most popular, and should I say the most relevant, but to my own conscience I would say they are the most popular and relevant to the most relevant to me.
All right, so the overview of natural school of thought simply it was propounded by Thomas Aquinas, which is the most prominent proponents, although we still have the early Greek philosophers, the Stoic philosophers, Aristotle, Plato, and all the rest. So, but the simple thoughts around the natural school of thought is, first of all, that it is that law comes naturally to man from God. So it looks at law as divine, first of all. Then it goes on to look at law as justice, fairness, and if you look at the textbook of Cousin, he gave some characteristics of law which has to do with it doesn't err, law never dies, it is an end in itself, and it helps man derive an end, not just being an end in itself, but it helps man as a means to achieve an end. So he also looked at law as the mother of all laws, through which other laws gain its validity. In other words, he's trying to tell us that if, for example, a written law, that is according to positivists, is not in accordance to a natural order or a natural law, it is already void, or it is invalid to the extent of its inconsistency. So it sees natural law as the law that governs other laws. Then going further, the early Greek philosophers thought of it as the law that is rational. It comes by virtue of man's reason. This is to say that law comes natural to man in the sense that naturally you know what is right and what is wrong. But however, if you look at this, you find that the criticism already as to this is what is natural to Mr. A may not be natural to Mr. B. So it begs a question of, so what is justice? Because to Mr. A, justice may be to follow the due process of the law. To Mr. B, justice may be to leave it to God. To Mr. C, justice may be to beat the person or to retaliate immediately you get offended. So what is natural to this person may not be natural to the other person. Some believe in dominating others. Some see that domination as slavery. So in this sense now, there is a little confusion as to what is really the true law, if you look at law as what is universal to everybody. So going further, the Stoic philosophers did something like that and said that law is common to all men, and all the rest. So looking at the nature of their theory and how it is based on morality, wrongs, and not necessarily what is contained in the book of law. The criticism around this is that, first of all, it's not enforceable because the enforceability is a little has a you have a little issue as regards to enforcing natural law because according to section 36 CFRN 1999 sub 12, it tells you that any law that is not written down, you cannot actually convict the person for any law that not written down in the constitution. So also it looks at it means that these laws are not enforceable, and I've already mentioned the criticism as to the uncertainty as regards to what is really the law based on the fact that they posit that it is what is rational to man or nature. So moving forward, without further ado, we will look at the positivist theory of law, which has to do with the command theory by John Austin talks about law as a command made by a sovereign to his subjects, backed by sanction. So the major elements there: sovereign, command, and sanction. So, and he then goes further to mention the fact that this person must be someone that has a kind of authority that everybody must obey, and he is an uncommanded commander who by virtue of his status, everybody is bound to obey. So the simple critics around this is that, first of all, it leads to dictatorship and slavery because if if you say that this person is above the law, it means that he has the right to set any law and make every other person to obey it. And then by the power of the law, you are enforcing slavery in these guys. Then the second one is the fact that he posits that sanction is necessary to enforce obedience. However, we all know that the presence of sanction in every state doesn't prevent people from really disobeying the law. We still see prevalent cases of murder and all the rest, even though there is a law against most of them, just like our criminal law and penal code says. So this is the few points I would like to make here under this overview to avoid much taking much of our time. But before I will conclude and hand over to my friend and colleague here, I would like to say that there are several ways whereby this positive theory of law or their concept of theory of law, their concept of law and the concept of natural skill of law like combined. For example, in the case of Shaw and DPP, yes, moral values do not affect the positive school of law, but you see that, you understand that in that aspect, the morality as regards to the fact of the case affected the decision of the court. Also, if you look at the case of Abacha and Fohemi, the African Charter of Rights, Chapter 4 of 1999 Constitution, you will see that this is where natural human rights, which is believed to be coming from God, is actually enforceable. So these are the few places where it relates. And I would like to also mention that another part of the positivist theory of law is the Hans Kelsen theory of law, which has to do with, he focused mainly on the hierarchy of norms while agreeing with the sanctions as regards to backing every legal principle. But then he mentioned that in every society there are basic norms which are seen as the ground norms through which every other law gets its validity. Thank you very much as I hand over to my colleague to talk about the relevance of these theories of law in the modern Nigerian legal system. Thank you very much.
Okay, good afternoon once again. I thank my colleague here for doing justice to these schools of thought. Yeah. Now, my first question to the naturalist school is this, and which breaks my mind so well is the fact that they say the naturalist school is um, law as given to man, as given to man by God, yeah. And then it was gotten from right reasoning, it was gotten from nature, from the conscience of man and nothing else. Now my question is this: could we say that Cain and Abel in the Bible, the never Cain does not have conscience, or should we say God did not create him with that right reasoning as per se, as Thomas Aquinas and the propounders of the natural schools of thoughts has said in their own theory or philosophy of law. I won't buy that idea. He was actually created with conscience. And then bringing it down to our African society. Before now, we know that the killing of twins was actually legal in the African legal system, right? Whether or not it was written, because before the coming of the British, we never had should I say, we never had a comprehensive written law, right? Yeah. So we could call it practices, but they are still laws. Could we say that then the Africans, God did not create them with conscience for them killing twins, and then you're telling me that the natural law school is the best of all, and then you're saying that should we say the Africans, they don't have conscience, that's why they are killing twins, God did not create them with conscience? Okay, if you say that, then I will take you down to Europe, right? There was a time in Europe where they were killing ladies for being witches, right? Yes, they were killing them for being witches, those that have some powers that were given to them by God, should I say magical powers, and then they know how to heal. If you look the history of Europe, they were killing them, right? Because they believe that they are not humans, right? They had some bad spirits in them. We also saw that in the film, that Merlin, that there is a film Merlin. Yeah. That was a typical European society as of then, including England. Those practices were there. Can we say then, when they are killing those people, can we say that England as of then, they are not created by God? And then, if we say they are created by God and God gave them this law from birth, can we justify that they are killing people as of then, looking at, saying, relying on the fact that God actually told them? Why the Bible says, thou shalt not kill? And so, any form of killing is killing, right? So, to my own conscience, I would say that looking at what has happened and the societies we are in, Africa and the rest of the world, I would say to the Nigerian society, which is not an homogeneous society, it is an heterogeneous society, where we have so many cultures, we have so many religions, you have so many beliefs and everything. The positivist school, the positivist theory is the best theory that fits the Nigerian society. Now, for example, the northerners, they believe that one should not actually take alcohol, right? And then they actually included it in their own legal system, which is the penal code.
Yes.
But coming to the south, there is nothing like that in our criminal code. Reason being that we know that the southern area of Nigeria is should I say multifarious society, where you have both the atheists, we have the traditionalists, we have the Christians, we have the Muslims and other religions. So I would say, like, the question is, how is it applicable, right? Which is better in our Nigerian society, Nigerian legal system? I would say that the positivist school, which says that law is as it is given by man, a sovereign, backed by sanction. And one would say, what about the Wills Act? And did the Wills Act force you to write your will? But I will tell you that even the Wills Act that you're seeing, it has an undertone of sanction in it. Even the Marriage Act. But do you know what? The Marriage Act and the Wills Act does not act until you force them to act. That is to say, if you marry under the law, right? If you marry under the act, then whatever punishment is in the act is holding you. If you write your will following the Wills Act. Whatever that was stipulated, you must be followed, or else whatever you wrote is of no importance. So to my own conscience, I would say, and of which I have seen in our society, that the positivist school is the best school to be adopted and has been over the years adopted in the Nigerian legal system. Now, I will take your mind, I will cast your mind back to the case of Ayoko and Fabemi before I round up. Now, if you look at that case, the thing will show you that though adultery as we per se, in every right thinking member of the society who is religious in the Nigerian society, they will tell you that adultery is a sin. Going back to the Christian faith, if you come down to the Muslim faith, but in Ayoko and Fabemi, the court took them back to say, oh, though this sin is actually a sin to the conscience of a Muslim, to the conscience of a Christian. However, by virtue of section 36 sub 12, which has stated that any crime that was not clearly stated in any book and its punishment prescribed, one cannot be punished for it. Thus, Ayoko was set free because where she committed the adultery as per se, there was no law holding her not to commit it. Thus, to the Nigerian society and the Nigerian legal system, knowing very well that it is an heterogeneous society, I would say, and I would justify this, that the positivist school, which believes that law from a sovereign, which per se from Nigerian aspect, we could say the government, yes, whoever is there, and then the parliament and the rest, they have the right to make laws backed by something which must be obeyed and has been obeyed over the years, of which if you fail to obey, there will be a sanction. Now, lastly,
I wanted to ask you a question as regards to that point. The problem as to the positive school of thought over this, and I actually mentioned it, is that people feel like there's a tendency of it leading to slavery or dictatorship, in the sense that it plays. So in Nigeria, and if you're bringing home to Nigerian society, I think people will want to know, where does the sovereignty lie? Is it that the government has the sovereign power, or is it that even if they have the sovereign power, is there any limitation as to what they can do? And then, he says that he's not subject to the law. Does it mean that our Nigerian government is subject to the law? To what extent do we practice this non-subjection of our Nigerian government to the law? All right. I know. Maybe I took three questions at the same time. Maybe just take us first of all the sovereignty. Where the sovereignty lies in Nigeria, and who has the sovereignty really, and then the limitation. If the green is the government, what's the limitation? Okay. Take us through that one, please.
Well, thank you very much. Thank you for that wonderful question. Now, if you read section 13 of the Constitution, if I'm not mistaken, section 14, right? Sorry, my bad. Section 14 of the Constitution, where I say sovereignty belongs to the people. And now, originally, sovereignty rests with the people, right? Okay. But this sovereignty is transferred to the government by virtue of voting, right? We are actually giving this sovereignty. Okay, you government, you're the one representing us. This sovereignty now, we the people who voted you in. And so the government now, in the Nigerian society, the constitution per se has told you that sovereignty lies with the people, but we know that through we casting our votes, we have actually surrendered some of our rights, some of our sovereignty to the government. Now, the government has limitations, let me tell you. Now, their limitations is actually the law, right? Now, the government cannot do anything, cannot act when the law say they should not act. Okay. For example, if the law say, okay, let's just use the Ayoko and Fabemi's case for example, where the law say, bros, don't prosecute somebody for adultery. The government cannot take her and put in prison because she committed adultery. So the law is the limitation of the government. This same law that gave them the power has also limited them not to act in some ways.
Okay, now because of time, I will just go in the second question, which will be the last. As regards to the virtue of the sovereign being a non-commanded commander, how is this applicable in Nigeria?
Well, that's a nice question.
And like, if they are not subject to the law, to what extent is our leaders or government not subject to the law? And this takes me to maybe I'll let you discuss what maybe the immunity clause or something. You can just help us talk about it.
Okay,
Then.
thank you very much. Now, the uncommanded commander is the law.
Okay.
Yes, in Nigerian society, the uncommanded commander is the law because nobody is above the law. Okay. Right now, when they say when John Austin and his propagandas, they are saying the uncommanded commander during the early European societies, when these things they are coming up, you see the king was the uncommanded commander, right? But now presently in our society, the law is the uncommanded commander, right? To my own conscience, and so the law has given the government to act. But the law did not actually give them the commanded commander power. Reason being that they cannot act like I see, they cannot act when the law say don't act.
Okay.
Yes, and so the immunity clause, like it has been popularly said, can we say because they have immunity, that means they are the uncommanded commander? Can I tell you that there are some things the president will do in his own personal capacity? You can actually key into it. You see criticisms in the online. They criticize the government. Can you criticize uncommanded commander? There are some actions the president should take, and they will tell you that, Mr. President, this one you did is not right. You understand? The public will speak up.
Okay.
Please, the immunity is for on your own seat. What you act with on your seat, not your personal.
But can you justify that the immunity clause as in what the president does by virtue of his seat? As regards to the immunity clause, as pertain to Nigerian constitution, which prevents suits against the president against the governors and president based on what they did in their office. Can you justify it? Do you think it's really necessary? Do you think it's right or wrong?
Okay, I feel like the immunity clause is a very, very important clause. Reason being that, the president is the commander-in-chief of all armed forces in Nigeria. He has a lot on his table. And so if they keep suing him for every little thing he does, that means he won't have the time to run the affairs of the country, right? You'll be going from one nuisance case to one another case. So many, like plethora of cases against the president. He might not have the time to run the affairs of the government of the country rather. And so I would say that immunity clause that was given to him by the same law is a very, very important clause.
All right, our dear audience, my my legal colleague here have actually, or my learning colleague here has given his own position, and from what he said, it's clear that he adopted the positivist theory of law. I don't know what your comments would be. You can choose your own. You can adopt your own position. Thank you very much. See you next Friday.
Inspired to lead by example and raising leaders with solution.